Thank you, Mayor. Appreciate it. I owe you one though for having me come up after all the good times, and now I'm going to bore them. It's going to look even worse. Thank you very much. I clearly didn't know Tony the barber, but I want to say not only condolences to his family, but congratulations as well, because obviously he was a pretty good guy, which you can't handle. So, my name is Judge John P. O'Donnell. I'm a judge on the Cuyahoga County Court of Common Pleas. I also want to acknowledge my judicial colleagues, Judge O'Connor, Judge Beck, and Judge Ross. I want you to think about, if you were going to start a new city or a new state, you're just going to start from scratch. You would probably have a police force. But I want you to think about, would you give those police officers guns? Would you give them guns? I bet that the large majority, if not all of you, say that you would. But I want to get you thinking about that for this reason. I want to talk to you for a minute about police use of force, which has been in the news a fair amount lately. And I want you to know a little bit about the legal standard for police use of force. I'm going to tell you in a minute about how I'm running for the Supreme Court and how I'm better than the other candidate and you should vote for me. But I like to, when I come to a place, give you a little bit of knowledge that I think you can use about a current topic. So I want to talk to you about police use of force for just a couple minutes. The Constitution of the United States, the Fourth Amendment, prohibits the government from doing unreasonable searches and seizures. That is a constitutional prohibition. But of course the term unreasonable is not exactly defined. When a person is arrested, that is a seizure. When a person is killed in the course of an arrest, that is considered a seizure too. The only prohibition against that is it cannot be unreasonable. There is no law, there's no statute that says you cannot shoot a perceived felon, you cannot shoot a person who is presenting you with a threat of death or great bodily harm. There is really just a Constitution that controls this. So when you hear about a police officer having shot somebody, and typically you hear about that when the person is killed, I should say when you hear about a police officer killing somebody, the question is whether that police officer had an objectively reasonable fear that his life or the life of someone nearby was either in danger or subject to great bodily harm. So what it comes down to is the police officer's perception. Now, an officer can't get out of it, so to speak, by just saying, I thought I was going to be killed, so I shot. There has to be some objective evidence supporting that reasonable fear. So, in Beaver Creek, not all that far from here, in the Walmart, where about a year ago, a person was carrying around what looked to be a rifle, and the police were called, not knowing that he picked up this merchandise, and it probably wasn't even loaded. All they knew was they were coming to a scene where a guy supposedly had a rifle walking around the Walmart, and they get there, and I don't know what they see, to be honest with you, but this case you probably heard about. The customer carrying around this gun was shot and killed by the police. The prosecution, as I recall, did not even present that case to the grand jury. That tells me that the prosecutor was satisfied in the investigation that the officer who shot had an objectively reasonable belief that he or people nearby were subject to imminent death or great bodily harm. And I bring this up for two reasons. First of all, this is in the news a bit lately. Second, I became somewhat of an expert on this myself when I was asked in the last year to preside over a somewhat similar case in Cleveland. About 2 years ago, the police in Cleveland were led on a 22-minute, 20-mile chase by an old 79 Chevy Malibu. It was being driven by a guy named Timothy Russell, who had just gotten out of prison where he had been because he ran from the police, caused an accident about a year or two before. His passenger in the front seat was a woman whose cousin testified at trial that she had a history of threatening violence against the police, and she was mentally ill. Both of them were high on crack cocaine, and as I recall, the driver was also drunk. So they led the police on a chase that reached, at times, 110 miles an hour. During the chase, the police observed what they thought was a gun being pointed at them by the passenger a few times. Eventually, the car goes into a school parking lot that doesn't have an exit other than the way it comes out, other than the way it came in. So the car goes in and is followed by a couple of police cars. He gets to the back of the parking lot, sees that he has no way out, turns around and gets stuck on this island. It has a curb and it has a street light and it has some grass. He is stuck there momentarily, so the first officer jumps out of his car and starts going over to arrest them. Just then, the Malibu sped up and got unstuck and was coming straight at the officer, who, as he dove out of the way, shot at the Malibu. It was dark. It was after a 22-minute chase where many officers thought a gun was being pointed at them. By the way, the whole chase began when what was reported to be a gunshot came from the car right across at some police near police headquarters in downtown Cleveland. So this officer shoots while the Malibu is starting to speed out towards the rest of the other officers. Hearing those shots, the other officers start firing, thinking it's coming from the Malibu, which is speeding at them. Eventually, 13 officers fired 137 shots. After that, both occupants were killed. One sustained 24 bullets and the other 23. The Attorney General investigated and decided that no criminal charges were warranted, but the local prosecutor eventually presented to the grand jury, had one officer charged with voluntary manslaughter of both individuals. The other 12 were not charged, although they still were exposed to the possibility of charges because they did shoot, and it was tough to tell whose bullets penetrated these people's bodies. The case was arraigned, and I was assigned to preside over this case by random draw. I'm one of 34 judges up in Cuyahoga County. I was happy to get the case because I'm very confident in my ability to preside over a constitutionally fair trial. And the hard part of the case was deciding whether the defendant was guilty or not. And that would be the jury's job. So I could preside over a fair trial and then leave the rest to the jury, the tough part to the jury. Well, as we got close to the trial, the defendant, who earlier had tried to disqualify me as being biased against him, decided that he would waive his constitutional right to a jury trial and have the case tried directly to me alone, where I would have to decide whether the defendant is guilty or not guilty. He filed his jury trial waiver, and the first thing I thought when I saw it was, oh darn. Except I didn't say darn to myself, but I'll keep it G-rated here. Then the pressure was on. So I became, as I said, I think an expert to some degree on police use of force. I wound up hearing the case for over a month in April and May of this year. Rendered a decision on Memorial Day weekend. People can agree or not agree with my decision, but I believe I made the right decision. I believe I explained it properly. But it was a no-win situation for an elected official. If the officer was found not guilty, half the community is upset, thinking that he committed, many people thought it was a murder more than a voluntary manslaughter, but the point is, one half is going to be upset no matter what verdict is returned. I did, as I said, what I thought I had to do, and I have been, I think, praised in some quarters for my decision, and I think reviled in others. But this then leads me now to the Supreme Court race. So I gave you what I like to think is the information you could use. You learned a little law tonight. But now I want to tell you that here's the reason I want to be your Supreme Court Justice. the Supreme Court needs justices, first of all, who to some degree share your perspective. I can't say that I will go there and I will be the quote-unquote democratic justice, because legal issues don't always have an answer that you as a Democrat might want them to have. But I can tell you that I share, I believe, your perspective in many ways. I probably share your perspective in many ways of workers' rights, individual rights, and collective bargaining rights. But so, I think I share your perspective, but more than that, I'd like to believe that I have proved, and I'd like to believe that I've just given you an example of how I proved it, that I can do what is right, and in the end, you want that out of any judge or justice, whether that person is a Republican or a Democrat. So, hate to bring you down to talk, I come here and talk about cops killing people, but like I said, I'd like to give you some information I think is timely, and I hope that 15, they might seem like long months to you, but they're going to go by quickly for me. 15 long months from now, I hope you will remember Judge John Cuyahoga for the House. Thank you.